We have quite a bit of Lori Vallow court documents to talk about today. If you haven't yet, make sure you subscribe to the channel because we are going to be covering her next trial daily with recaps of what you have missed. But let's get into this document here. To start us off, there are multiple documents, some handwritten, that we're going to get into today. So this is a minute entry. The court has received and reviewed the following. Defendant's motion for new trial, filed May 1st, 2025. State's response to defendant's motion for new trial, filed May 6, 2025. And defendant's reply to state's response to defendant's motion for new trial, filed May 14th, 2025. The court will address the issues in order in which they appear in the defendant's motion. And they begin with what I think is really a hot button issue, juror misconduct, because some people do think that this was handled incorrectly. The defendant alleges there was juror misconduct based on a statement Juror 15 made to reporters following the verdict, wherein he stated, "You know, I feel sorry for her driving home yesterday. I was like, God, she's spending the next 3 lives in prison in a cell." On its face, the statement would seem to indicate the juror violated the admonition and researched the defendant acquiring knowledge about her sentence imposed in another matter prior to and we'll go to the next page, but I do want to mention, since we're starting with juror misconduct, that there is another Lori Vallow filing that I do not have that talks about Juror 15 and does confirm that Juror 15, the one that made this statement, is the same juror that was texting during testimony. So I mentioned before people were claiming that, but I never saw like a big verification. Lori Vallow is saying it's the same juror in her one document that I don't have, but I feel like it's worth mentioning. And we continue. Lifting of the admonition, however, the state's response included multiple additional media clips of statements Juror 15 made both immediately prior to, after the statements referred herein above, in every one of which he specifically denies any knowledge of the defendant's other case/sentence prior to the court releasing the jurors from the admonition. At best, Juror 15 gave a single statement, which seems to be in conflict with all his other statements when he specifically denied any misconduct. Here on the limited record of the pleadings before the court, there being no affidavits or sworn testimony evidencing any misconduct as contemplated by Rule 24.1d, the court does not find clear indication of juror misconduct, let alone any evidence of prejudice to the defendant. Juror misconduct requires a new trial only if the defendant shows actual prejudice or if it can be fairly presumed from the facts. So, I had issues with this juror personally when it came out that he was texting during the case. I don't remember, but I remember for sure, but I remember claims that he was also one of the jurors that was talking during testimony as well. And in both cases, I said whoever the jurors are involved shouldn't be there, right? He also talked about not wanting to be on the jury. So I'm going to be honest, I don't think he's absolved of not looking it up. I really don't. But how do you prove it? They would have to get his phone records and search records, and I don't think they're going to do that to a juror because they made one statement. That would be the way to prove or disprove a lot better, more accurately. Most likely, there's someone, if they were going to do it, they'd check it on their phone, and you could maybe get a hold of the text and make sure he was actually texting who he said he was texting and it wasn't about the case. I don't know if any of that's been verified, or maybe he willingly showed it to the prosecution. I don't know. But the judge isn't going to go with it. Probably going to get brought up on appeal, though, if we're being real. Preclusion of Tylee Ryan and Alex Cox statements and impermissible testimony by Detective Daniel Coons. Oh, before that, let's go down to here. Even if there were misconduct, the defendant's own motion undercuts her argument that prejudice exists because she points out Juror 15 said he was leaning toward not guilty. Through deliberations, a distinct indication that if Juror 15 had any extraneous information at that time, it did not affect his consideration of the evidence. I mean, no. Because he changed his mind, right? Like, I'm playing devil's advocate at the moment. No, he changed his mind, so it is a little weird. I mean, it's not weird that you would change your mind, right? But it's weird he makes this statement and then changes his mind. Both of those things, because he could have changed his mind after looking it up. I don't think... I know what the judge is trying to say here, but I don't think it really fits, in my opinion. The court issued a preliminary pretrial ruling on March 11, 2025 regarding the inadmissibility of statements made by Tylee Ryan and Alex Cox. This is interesting, because remember, during her last trial, or if you didn't watch her last trial in Arizona, they weren't allowed to use the Tylee Ryan or Alex Cox statements. The court's ruling stated that out-of-court statements made by Tylee Ryan and Alex Cox appeared to be hearsay, and the defendant failed to establish that any specific statement was either non-hearsay or fell within an exception to the rule excluding hearsay. The court went on to give the defendant the opportunity to offer specific statements at trial by saying the defendant could re-urge the issue outside the presence of the jury. Not only did the defendant never take the court up on its offer, during trial, the defendant's motion for a new trial and reply only argue in generalities, failing to set forth any specific statement that should have been admitted into evidence under either a non-hearsay exemption or an exemption to the hearsay rule. And here's the thing, right? If they let in either of their statements, I think they have to tell the jury the story of Idaho to give the jurors context, but obviously Lori wouldn't want that. As to Detective Coon's testimony, the defendant argued the detective did not have foundation to testify as an expert. Sufficient foundation was laid for the detective to give his opinion. The defendant has offered no specific information as to what additional foundation should have been required. To the extent the defendant believed the witness was not qualified, or his opinion should not be given weight by the jury, she had the opportunity to cross-examine the witness about his qualifications or lack thereof, as well as a basis for his opinion. That she did. She did bring up complaints about him, and she had chances to talk to him, and yeah. And at the bottom here also it says, neither the court nor the defense chose to have an affidavit prepared by juror 15 or any other juror, so the court is left with the media clips provided in the pleadings. Yeah, so that's another thing. They didn't even get an affidavit, either side. I don't know. I feel like it wasn't... I wish it would have been taken more seriously as soon as the texting happened. I feel like they should have removed him. But they also had lost multiple jurors already, so maybe that became a factor. But is it okay that became a factor? Because now we have this situation. It's going to be in the appeal. The defendant also argues she did not have time to rebut Detective Coon's testimony. The record is clear that the defendant was offered more time to prepare for trial and declined. That's a key thing with Lori, right? She wants to go to trial, doesn't want to wait because she's here for the other women in the jail. And it's a family tragedy. She's done interviews before the trial, after the verdict. She's done that. So she is purposefully not... She doesn't give herself enough time to actually do the process, especially pro se. Moreover, the argument the basis of Detective Coon's testimony was the walkthrough of Alex Cox is not supported by the record. The defendant's reply for the first time raises the additional argument that Tylee Ryan's statements also form the basis for Detective Coon's testimony. I mean, if you want to make that argument, you had to do it before trial and use it as a reason to bring her testimony in. But again, you're opening the door to Idaho, I would imagine. I don't see a world where you could bring it in without opening the door to Idaho. But she lost, so do a retrial, have another campaign of harassing the people she wants to harass, and if she loses, she loses, right? She already lost once, she just gets to retry, it doesn't matter, it's the same outcome. Same outcome whether she wins or loses, really, because of Idaho. Again, there is no evidence of this, and the defendant offers no specific statement by Tylee Ryan or Alex Cox to support her assertion. Even if what Alex Cox and or Tylee Ryan told Detective Coon somehow contribute to his opinion, the defendant never asked the detective those questions. Did anything Alex Cox show you or tell you contribute to your opinion? This type of question would have been permissible, however, the defendant did not ask it, nor was she ever precluded from asking it. And that's, again, a case where she's her own lawyer. She might have thought that because everything about Alex Cox was basically being said, what he said was being said, no, you can't talk about that. She might have assumed asking that wouldn't be allowed, but that's her own fault. She's pro se, right? The court finds the statements of Tylee Ryan and Alex Cox were properly excluded, and the defendant has failed to raise a single specific statement that should have been permissibly allowed under the rules of evidence, nor has the defendant established Detective Kuhn's testimony was improper. And then we have the discovery violation stuff, which is... it's interesting. It's a little technical, I think. I've noticed some comments in other videos from other people where people seem confused where this comes from. From my understanding, she got a readable format from the phone, but what she wanted was an extraction that wasn't in the readable format, and then her side couldn't figure out how to turn it from the extraction to readable. And she's like, well, the extraction software has a new version now, but she didn't show anything. And she made her suggest her demands for this evidence too late. And she got it because she'll need it for the next trial, the phone extraction. But although the defendant's motion alleges the contents of the hard drive are exculpatory, she never articulates any single item whatsoever that would constitute exculpatory evidence. Again, merely stating something is exculpatory does not make it so. The defendant's request for additional discovery related to Charles Vallow's phone was accommodated. The state had previously disclosed all evidence it had in its possession at the time. The defendant requested access to the actual phone to run a new examination with software that had been updated since the phone was examined several years ago. The defense has offered no evidence on any additional information was obtained from the phone, let alone it being exculpatory. This court finds no discovery violation. I think we all saw that. And then we're going to get into prosecutorial misconduct. The court finds nothing in the defendant's allegations come close to establishing prosecutorial misconduct. The state is allowed to argue reasonable inferences from the evidence presented. The defense does not have to agree with those inferences and is permitted to argue the evidence should be interpreted differently. The defendant argues in her reply for the first time that both the state and court violated a defendant's rights under the Religious Freedom Restoration Act. Although new arguments are not to be considered when raised in a reply, the court will nonetheless, and we'll go to the next page, but isn't that so interesting? She's now going to be like, oh, you're against my religion. Really, Lori? Address this. The RFRA protects religious freedom and prohibits the government from substantially burdening a person's exercise of religion. There is no conduct, but either the state or court that somehow infringed on the defendant's freedom to practice her religion. Nor is there anything about the trial that impacts the defendant's freedom to believe whatever it is she chooses to believe. Moreover, the RFRA does not protect someone from committing criminal acts in the name of religion, nor does the RFRA prevent any person from disagreeing with another's belief system. Here, different witnesses may have had different interpretations regarding who Nephi was or the significance of his story. The defendant had an opportunity to cross-examine those witnesses regarding the same. None of this infringes on the defendant's religious freedom. For these reasons, the court finds no prosecutorial misconduct. And, I don't know how to even... Actually, I do. I do know how to put this. So, imagine there was a case, and someone said, we need to deal with them like Jesus, right? And the victim was found crucified to a cross, and that is used in court. That statement by the perpetrator. This would be like the perpetrator saying, well, I believe that Jesus, he actually choked on haggis when he was visiting Scotland, and therefore it doesn't include the crucifixion, and you're wrong. The prosecution can still say, yeah, no, here's other people that knew you in the same church, in the same religion. This is what it generally means. People know this. Here's the comparison. Here's what happened. That's not violating your religious rights. Court's lack of impartiality. And this is one that some people I've seen are on Lori's side. I'm not, and I'll probably talk about it more as we go. The defendant alleges the court was not impartial because the court struck two of the defendant's witnesses from the defendant's witness list. That's not the part that people defend, but we'll continue. Contrary to the defendant's assertion that no rule of law or evidence requires her to establish a witness's relevant information, Arizona Rules of Evidence 601, 602 require just that. Prior to trial, the defendant was given an opportunity to make a general offer of proof as to what relevant information the witness would provide, which the defendant was unable to provide. When the court precluded the witnesses, the defendant also advised by the court that during the course of the trial, she believed those witnesses had relevant information. The court would revisit the issue. Thereafter, the defendant did not, again, offer any witnesses, even though she was specifically told she could re-urge the issue. In addition to her motion for new trial, the defendant offered no further information on what testimony the witnesses would have given if they were permitted to be called as witnesses. So, she screwed herself there. And at the bottom of here, it says, the defendant's reply seems to argue the defendant was precluded from calling all 12 of her witnesses, which is not the case. The defendant chose not to call any witnesses during the defendant's case in chief. Yeah, so anyone that didn't watch the trial, she didn't put on a defense. She didn't call witnesses. She didn't testify. So if you're going to be watching the trial and you're planning to watch the trial or trying to catch the end, it wouldn't be a bad thing to expect her to do the same. So if you hear the prosecution's going to rest, there's a decent chance that Lori's going to rest. They're going to do the closing, and then we're going to have a jury, and they might not take long. Just so you can try to time you're watching when you know to watch Twitter for a verdict or watch YouTube for a verdict. The defendant also argues the court demonstrated a bias on the court's comment. This is the one that some people agree with Lori, that I don't agree with, made while overruling the state's objection to the defendant's questioning of Serena Sharp. The state was objecting to the relevance of the question, and the court thought the question had some minimal relevance based on the context of the defendant's line of questioning. The court notes the defendant argument as to why the question was relevant was not in line with why the court surmised it was relevant. While the court's comment was not necessary, it does not evidence bias, nor does it mean the court was demonstrating any partiality. It's a lot of words. Let me try to remember how this went down. The state objected. Lori could not properly put forward an argument against the objection. The judge essentially helped Lori by saying, well, as far as you're comparing yourselves to biblical figures, which is what she was doing and is basically the only scope in which what she is saying would have been allowed to be talked about. And Lori and some people are trying to take argument with that, but it's not a bias because that is the exact small little framework that she could do this. Now, the argument that could be made is that should have been set at a sidebar. The jury couldn't hear it. I don't remember if that was one of the days that had headphone issues because Lori can't approach the bench. I don't know if that was the day with headphone issues or not. That could have been why he said it out loud. But I fully think what he said is okay. You could maybe argue it should have been said in front of the jury, but she was comparing herself to biblical figures translating. Okay? So if she's doing that, and that's what she's trying to compare herself to, and she's asking about other people in the Bible that she compares herself to, the way the judge worded it to me was perfectly okay and doesn't actually show any bias, which of course is going to be the judge's finding pretty much. It wasn't needed, but he did it. I think it actually was needed. I don't think it's a big deal. I don't think it's going to help her appeal. Nonetheless, the court acknowledges the court's comment was unnecessary. Again, I don't think it was. I don't think it wasn't. I just think maybe it should have been at a sidebar. And the court should have simply overruled the state's objection without comment. I don't think that should have happened because I don't think she should have been able to have free reign to argue religion on the stand. Moreover, the court has been presented no evidence whatsoever that this comment influenced the jurors. The thing is, if the judge overruled, Lori was going to say the same type of thing, slightly different, again, go into a realm she wasn't supposed to, or it wasn't relevant to the trial at all, and we were just going to be back with another objection until it was narrowed down. Having carefully considered the defendant's argument, all of the briefing and record, the court finds the defendant received a fair and impartial jury trial, and the defendant has failed to establish any grounds for a new trial, and the order is denying the defendant's motion for a new trial filed May 1st, 2025. So this is the start. There's more filings. Don't leave yet. We got more to talk about. But this is basically, I think, the only file on her previous trial we're going to talk about. Next, we got to go into her new trial. There's another trial. This trial starts next month. End of this month. Jury selection on the 29th, something like that. Anyway, which, by the way, I am planning to cover. I have a game coming out on the 30th. I might be playing with friends, but I don't think it'll have anything to do with this case overlapping. I just won't get to play as much. I have a game on the 13th that I generally play with friends. I might have to miss that day purely due to this case, but it's also possible it ends by then. We'll have to see how things progress. At a glance, it appears more clear than the Sarah Boone font, so we're off to a good start. We'll see how my readability is with this. The defendant, Vallow Daybell, requests this court preclude all evidence of phone data and text messages related to Alex Cox. Immediately, my thought is, this didn't happen last trial. Why would it work in this one? Pursuant to Rule 801C hearsay, Rule 801D procedural rule, or context statute, hearsay is inadmissible unless it is defined in a non-hearsay under Rules of Evidence, Rule 803. In order for the text message to be relevant, it must establish the defendant's intent, knowledge, and absence of mistake. The alleged co-conspirator is deceased, therefore the state cannot establish Alex Cox's intent, knowledge, or absence of mistake. That is just not how that works. You can get a lot of intent from text messages. Let's ask the jury at the last trial what they think the intent was with Be Like Nephi. That had a very clear intent. The prosecution put it forward. The jury agreed. The judge agreed it was okay. Clear intent, actually. In fact, Lori, in her argument about religion, when it came to that text, was just arguing that it had a different intent, which is still admitting the intent was readable. Her interpretation of that intent is what she was trying to change. Not going to get anywhere. Here we get to the facts, which is going to be, some of this seems a little hard to read. We're going to struggle. In something's, it looks like it says almost O instead. Phone messages are inadmissible, might be a case. Federal Wiretap Act, SCA, ECPA, Constitution, Article 3, Number 2, State Invasion Privacy Act, prohibit unlawful access to stored electronic oral communications, Facebook, torts, IPA, bias reading, attempted reading of any messages, another case law. The data contained is unreasonable. Servers, web hosts are oversee breaching foreign treaties. This has not. Are you arguing, Lori, that a phone extraction is violating an international treaty? Please argue you're your own country. Please go sovereign citizen. Please. Pixel tracks IP addresses and devices. 10 violating USCA Constitution Article 3. He has is it his Pixel phone? Are you saying that his Pixel phone violated the Constitution? And search warrant IP addresses and devices. Maybe it detected Lori being nearby or something. Because she has the evidence, right? And the search warrant application for location information violates pen, register, and tap and trace cell style location info stored. Communications Act. Something does not permit government to obtain requested ping warrant. In Dimstead proves under Wiretap Act the telephone messages cannot be intercepted. They weren't intercepted, Lori. They're on the phone or they're in the records, right? Am I crazy? Is she arguing that your cell phone provider shouldn't be able to have access to your messages for them to actually be able to send them? Okay. A warrant must be provided in Riley. Data goes to cloud computing. And didn't they get warrants? Server connects to web hosts, which most are foreign entities. Web host opens something Pixel, maybe? Pixel tracks the device, servers, web hosts, Pixel's data, cloud computing. Would take numerous court orders? Is that an exclamation point she wanted to put there? Therefore, the data was illegally obtained according to Riley v. California. It is hearsay anyway? I'm pretty sure all of this is just nonsense, right? Like, if this worked, it would have worked in every single case ever. Right? Like, they got warrants. They didn't just steal the servers and take the data off. I hope. Also, if the state is using geofencing from Google or location history directly from the account, the state still cannot determine who was in control over that device at the time. Well, I mean, you might be able to. I mean, if someone has you really might be able to. If someone has the device, they're doing their daily routine, they have, let's say, a smartwatch attached that has biometrics, there are ways you can be 100% sure. Maybe they're taking selfies of themselves. We don't know. Lori should know. But there are ways that you can do that. You can also infer beyond a reasonable doubt who had it. So any data obtained would be pure speculation as to an actual person's location. I don't think that's going to play, because I've seen trials where, you follow the phone. Okay, let's say it isn't Alex Cox. Why is his phone there? Why is the phone communicating with Lori? Because I'm assuming they're going to have communications with Lori to further the conspiracy. Why is that phone then taken with it to do the conspiracy? It doesn't help Lori. A phone is a small device that can be picked up by any person and transported by any person. Yes, phones are a size and shape. The state has made no determination to the defense that any data turned over to the defense regarding Alex Cox is actually data from Alex Cox. Hold up. Can they use the fact that it was accepted in the last trial? Like, if Lori didn't argue it going into evidence in the last trial, are they allowed to use that against her in this trial? Maybe they can't. But I mean, it's the same defendant and law team, technically, because it's Lori. I don't know. I don't know how that works. I don't know how you try to make this argument. I mean, I guess you just make any argument you can, because what's it matter? This is your revenge tour, right? Any person who knows your email address could purchase a phone and attach your email address to it. No? Wouldn't they also need to know your password? The defense requests this court preclude all evidence of phone data regarding Alex Cox in this trial for all the reasons stated above. Yeah, I don't think this goes anywhere. I don't. Then we have this one, which is pursuant to the Fourth Amendment of the United States and Arizona constitutions, the defendant, Lori Daybell, requests this court suppress all evidence obtained as a result of illegal, unconstitutional, warrantless seizure of the Jeep Wrangler. Now, I like to go into these pretty raw, right? Get my real reactions as I read it. Sometimes I see things ahead of time, very little in this case. I'm going to take a wild guess that they have a warrant. Facts. On or about October 17th, 2024, approximately 7 months ago, Detective Ray Hermosillo of the Rexburg, Idaho Police Department, a state witness intended to testify to this trial, was interviewed on a podcast entitled Fax Me That Podcast. So she's using podcasts against people. Interesting. So she's now used YouTube interviews and podcasts. Okay, against witnesses. One time against a juror, one against a witness. During this 2-hour, 12-minute interview featuring Detective Hermosillo, the detective informs the public how he obtained the Jeep Wrangler, license plate, whatever, on November 4th, 2019. Detective Hermosillo indicates at about 5 minutes in that on Monday morning, November 4th, 2016, while driving home from the gym, he spots the Jeep in an apartment complex parking lot. He makes some phone calls and gets the Jeep impounded. He then... I'm trying to read that. He then gets on the phone. It's like... It's so... It's like I'm assuming that's like a reflection off of the ink. So it's like hollow, and that was getting me. Gets on the phone where Arizona and states, I got your Jeep. Arizona says, hang tight, we have to get a warrant issued. Detective Hermosillo then states that Jeep sat in our custody a week and a half till they showed up. Conclusion. So after seeing the Jeep Wrangler without a warrant, Detective Hermosillo then took steps to obtain a warrant. The defense requests all evidence obtained as a result of this unconstitutional warrantless seizure in violation of the Fourth Amendment be suppressed. A suppression hearing is requested. Okay, I think I have a state response to this, but you're saying he didn't say he seized it without a warrant. They impounded it when it was in a parking... It could have been illegally parked in an apartment complex and got impounded. We'll see where it goes. The state of Arizona, through the undersigned counsel, requests this court deny defendant's motion to suppress all evidence pertaining to the Jeep, since the Jeep was lawfully seized and impounded pursuant to a search warrant. And I'm going to assume that the prosecution probably has all the dates and maybe even times set up here, and it's going to be a lot more accurate than what was said off the top of the head on a podcast or was misconstrued by Lori. Let's go. On November 1st, 2019, Detective Ray Hermosillo with the Rexburg Police Department spoke with Detective Nolan McDermott from the Gilbert Police Department. Detective McDermott sent a probable cause statement to Detective Hermosillo, providing probable cause to seize a 2018 Jeep Wrangler, and they have a license plate and VIN number. So November 1st, okay? Detective Hermosillo went to the court on November 1st, 2019 and obtained a search warrant. So search warrant is available November 1st. Detective Hermosillo documented that he obtained a search warrant for the Jeep on November 1st, 2019 in his police report. The state recently obtained a copy of search warrant and disclosed that to the defendant. So Lori knows it was on the 1st. Okay. Then on November 4th, 2019, Detective Hermosillo observed the Jeep Wrangler at a location in Rexburg, Idaho. Detective Hermosillo had probable cause from Gilbert Police Department that the Jeep was used in the shooting in Gilbert, Arizona. He knew the Jeep was movable and could be driven away, and he had a lawful authority to seize the Jeep pursuant to the search warrant he obtained on November 1st, 2019. There we go. It's done. We can just call it done, right? He got a search warrant. He had a search warrant. He got the vehicle 3 days later. The timeline that Lori gave is not true. Detective Hermosillo documented in his police report that he seized the Jeep on November 4th, 2019, and he had towed it to the Rexburg Police Department. Upon seizing the Jeep, Detective Hermosillo realized his original warrant contained the correct VIN number, the correct model for the Jeep, the correct license plate number for the Jeep Wrangler, but there was a typographical error as to the year. The search warrant indicated the Jeep was a 2008 instead of a 2018 Jeep Wrangler. Detective Hermosillo immediately obtained another search warrant for the Jeep Wrangler. Search warrant was referenced as a typo in the search warrant number 60. A copy of the search warrant in Detective Hermosillo's police report that provided this information was disclosed to the defendant on February 26, 2024. So a typo. She's trying to get the entire evidence thrown out by a typo. And she knows that. Notice she didn't mention a typo in her filing. Although Detective Hermosillo could have lawfully seized the 2018 Jeep Wrangler based upon the probable cause provided by the Gilbert Police Department, he did in fact seize the 2018 Jeep Wrangler pursuant to a search warrant that he obtained on November 1st, 2019, 3 days before the seizure of the Jeep. So, he didn't need a warrant. He had probable cause, but he got a warrant. Merely innocent or negligent mistakes in an affidavit will not satisfy the first prong of the Franks test. In this case, Detective Hermosillo's affidavit in support of the search warrant contained a factual basis to seize the Jeep, Jeep's correct VIN, Jeep's correct license plate number, the Jeep's correct model, the Jeep's correct color. The typographical error of indicating it was a 2008 instead of a 2018 Jeep does not invalidate the search warrant. Furthermore, upon noting this error, Detective Hermosillo obtained another search warrant to correct the mistake. The 2018 Jeep Wrangler was lawfully seized pursuant to a search warrant. The state requests this court deny defendant's motion to suppress all evidence pertaining to the Jeep Wrangler. Yeah, I think they did a pretty good job making the argument there that, I mean, he did everything he needed to do. This is another one that I will say, just like the juror, it's not a good look to at least me, and I think a lot of people in the public. Maybe it's standard procedure and I'm not thinking it through all the way. That's why we have the state's response. But let's get into what Lori Vallow has to say. The defendant, Lori Daybell, requests this court dismiss the charge since the state of Arizona did not preserve the crucial evidence of the car door or the car window of the alleged victim. So, in her first trial, a key piece of evidence was a piece of wood that had a bullet that struck it, right? That was a key piece of evidence. And she even tried to bamboo shirts and all sorts of crazy stuff involving that. Now you're saying what was struck by bullets wasn't saved. It is a violation of the 6th and 14th Amendment of the United States Constitution, the defendant's right to due process, and the right to a fair trial. The lack of preservation of this crucial evidence is prejudicial to the defendant and to her defense team. The defense has requested of the state the actual door of the car that was allegedly shot and the window of the car door that shattered as a result of the alleged gunshot. It'll be interesting if they're going to argue that there wasn't a gunshot. And by the way, I've seen Nate Eaton's coverage. I know we're going to get new footage of body cams are going to be released involving the day of the shooting. So it's going to be stuff we hadn't seen before. It's coming out at trial. The defense was informed by the state that they do not have and did not preserve the car door or the window of the car door. Therefore, they are not available to the defense to their own independent investigation of these crucial piece of evidence to this case. That's kind of my question. Are they going to argue it wasn't shot at? There are nothing but pictures of the car door and the car window. Therefore, the defense and its experts cannot measure or test anything about the alleged shooting. This is a violation of the state precluding the defense from doing an independent investigation of this case. This is a violation of the defendant's 6th and 14th constitutional rights and calls for dismissal of this case. I mean, it doesn't look good. It doesn't look good that the door is not there, right? I'm very interested to see what the state has to say. The state of Arizona, through undersigned counsel, requests the court deny defendant's motion to dismiss since the Gilbert police did not act in bad faith when they decided not to preserve the Tesla and Tesla driver's side window, and any testing of the Tesla or window would not exonerate this defendant against the action she took in Rexburg, Idaho, to aid in the charge of conspiracy to commit first-degree murder of Brandon Boudreaux. I mean, I will say that even if they have her saying we should shoot him, can they prove it was with a gun, not a paintball, a BB? Is that what they were talking about? Well, a good way to prove that would be with a bullet in a door that could be tested to prove it was a bullet by the defense, so they couldn't argue against it. Just saying that they've got to have more. Memorandum of Points and Authorities. On October 2nd, 2019, Brandon Boudreaux was residing at blank in Gilbert, Arizona. That morning, he left his residence at approximately 7:25 a.m., took his children to school, dropped off his youngest with his soon-to-be ex-wife, and a lot of people have questions about that ex-wife. What did she know, and when did she know it? And went to the gym. Around 8:40 a.m., a neighbor was backing out of his driveway and observed a Jeep parked next to the Boudreaux's driveway. The Jeep was parked, so the front of the Jeep was facing the front of a white SUV. The neighbor noted that the Jeep was running and had tinted windows and a Texas license plate. The neighbor had never seen the Jeep before. At approximately 8:48 a.m., another neighbor was walking his dogs when he saw a Jeep parked with the front of the Jeep facing the front of the white van in front of Boudreaux's residence. The neighbor noticed the Jeep was running and the driver's seat was pushed all the way forward to the steering wheel, and he could not see the back of the Jeep due to tinted windows. Boudreaux returned home at approximately 9:13 a.m. As he approached his driveway, he slowed as his Tesla began opening the garage door. As Boudreaux slowed, he noticed a Jeep parked next to his driveway. Boudreaux watched as the rear window of the Jeep lifted up and a rifle barrel pointed out of the rear window. Boudreaux heard a loud bang and his driver's side window shattered. Boudreaux hit his gas and drove away from his house. Boudreaux called 911 and returned to his house. I would not have returned. I would have not. I'm going to tell you that right now. I would have driven to a police station and I would have been there. I would have been anywhere but that house. I'm not returning to that house unless I have a police escort. When Boudreaux put his Tesla in park, the driver's door automatically opened. The driver's side glass window fell out of the frame and onto the driveway. When police arrived, they noticed a hole in the driver's door frame and the driver's side glass laying on the driveway. Police recognized the hole as being made by a bullet. Gilbert police detectives went to the scene, took photographs of the street where the shooting occurred, the glass in the street, the white van, an area around the white van that was mentioned by neighbors, the Tesla in the driveway of blank, the gunshot hole in the doorframe of the Tesla, and the driver's side window that was laying in the driveway. The police also took photos of the Tesla with the trajectory rod in the bullet hole and the bullet fragments that they collected from the door frame. The Gilbert police report impound sheets showing that the Tesla and driver's side window were not impounded were disclosed to the defendant on December 12, 2023. Okay. But if this happened years prior, telling her years later you didn't save it, sure, she could have brought it up earlier, but it doesn't save it, right? I mean, okay. On October 2nd, 2019, Lori Vallow and her co-conspirator Alex Cox were living in Rexburg, Idaho. In the days leading up to October 2nd, 2019, Lori Vallow provided her deceased husband's 2018 Jeep Wrangler to her co-conspirator Alex Cox to drive to Arizona to shoot Brandon Boudreaux. Before Alex Cox drove to Gilbert, Arizona, he took the 2018 Jeep Wrangler to a tint shop in Rexburg, Idaho to tint the windows so no one would see him in the rear of the Jeep as he lay in wait for Boudreaux to return home. On October 1st, 2019, Lori Vallow rented a storage unit in Rexburg, Idaho. While Alex Cox was driving the Jeep to Arizona to shoot Boudreaux, Lori Vallow stored the Jeep's spare tire and rear bench seat in her storage unit. See right there, that's good evidence. Because I think there's video of a storage unit. While Alex Cox was committing the shooting in Gilbert, Arizona, Lori Vallow was in possession of her co-conspirator's cell phone in Rexburg, Idaho. Okay, I'm not saying this isn't good evidence, okay? I'm not saying it isn't good evidence. But what I'm saying is, this part here doesn't explain why the door wasn't saved. Like, good evidence, right? And also, there's the co-conspirator's cell phone bit that are trying to say man, I really want to know if she was sending things from his phone. Like, pretend he was somewhere else. We'll find out. That's going to be good. It's going to be good. I know it's going to be good. On October 2nd, 2019, at 8:02 a.m., the defendant used her co-conspirator's cell phone. I should have just kept reading. Used her co-conspirator's cell phone to call her cell phone to make it appear that her co-conspirator was in Rexburg, Idaho at the time of the shooting. Yeah, so this is probably where she's angry. They're using like connected devices or whatever. Like, there's a chance that if they like had two phones and they were doing some sort of like sharing software that like it linked up or they connected in some way, and it was known at that very time the two phones were together. So like, if the two phones are within a distance that they're connected, why would you be calling? That's not an alibi. Maybe that's what she's focusing on. And we have law and argument. The due process clause of the 14th Amendment is interpreted in Brady makes the good or bad faith of the state irrelevant when the state fails to disclose the defendant material exculpatory evidence. But we think the due process clause requires a different result when we deal with the failure of the state to preserve evidentiary material of which no more can be said than it could have been subject to the test, the results of which may have exonerated the defendant. Okay, so I can think of tests, right? Like, I think, understand, I'm talking like tests that probably wouldn't help, but you could probably come up with some bullshit test that you could argue could have been exculpatory that wasn't done. Like, was there any testing to check for certain that the damage to the car door was recent? Did they check for rust or any signs of rust forming? Could it have been a old damage to the door he's lying about? Like, there's things that could be said because this is Lori's revenge to her, right? I don't put it past her going, well, what if he shot his own vehicle door to blame me? That sounds very Lori-esque, right? Like, she was blaming Charles. She blamed Charles for following her when she took his phone and led him to his death, right? That's very Lori. So I'm sure she can come up with some arguments. She didn't list them. She didn't list them here. That's a problem. But she could have done that. In Youngblood, the Supreme Court indicated that the failure of the police to refrigerate the clothing and to perform tests on the semen samples can be at worst be described as negligent. The United States Supreme Court stated, we therefore hold unless a criminal defendant can show bad faith on the part of the police, failure to preserve useful evidence does not constitute a denial of due process. I mean, she's going to argue bad faith of the police, but again, she didn't put enough, I think, in her statement. She could have made a much better argument, but she's representing herself, and she's writing this out by hand. The defendant can argue that the police were negligent in not impounding the Tesla and or glass, but there was no bad faith in their decision not to impound the vehicle. No amount of testing on the vehicle by an expert would provide evidence that would exonerate the defendant from her actions that she was taking to aid her co-conspirator from Rexburg, Idaho. She claimed, okay, that Charles was actually part of a conspiracy to go after her. And in that conspiracy, she was trying to keep Brandon away, right? So I could very well see her trying to say, well, I'm going to argue that Brandon was part of a conspiracy against me still, and I can't prove that he faked the door because they didn't keep it. And that it's probably not going to work, but that's the argument that's the argument you'd have to go with, right? The defendant has had the police reports that show that Gilbert police did not impound the Tesla since December 12, 2013. She could argue, it's not a good argument, but she could argue, I'm not saying it would work, but she could argue, she could say it, she probably will, if she has a chance, that she was so busy with her other cases that she just couldn't involve in this one. She didn't know she'd be charged. The defendant has failed to show any bad faith on the part of the Gilbert police in their decision not to impound the Tesla or the glass window. The United States Supreme Court has held that failure to preserve useful evidence does not violate the defendant's due process rights. Here, the Gilbert police failed to preserve evidence of extremely limited evidentiary value and no value to exonerate the defendant's actions that were according in another state. Therefore, the state requests the court deny defendant's motion to dismiss. She's going to argue that whatever conspiracy they have evidence of on the phones is being misconstrued. We know she's going to do that. We're going to get a repeat of the last trial, I think, right? We're going to get, you don't know what we mean. You don't know what we mean on our phones. You don't know what our text means. We're big kidders. We always make jokes, right? We talk about movies or whatever else she talked about. Like, she put that forward. We're going to get that again. Obviously, it'd be better if they had the door, because this argument wouldn't exist. Do I think it's enough if it's... it's not I wouldn't say it gives me reasonable doubt, but I know too much about her at this point, right? It's just one of those things where I wish it was there. And I think everyone can agree with that. I wish it was there. I wish we had it. I don't think she'll be successful in getting everything thrown out because of a door. I don't think that's going to happen. But I think the door will be a core part of her appeal. I really do. So, there's some updates. There's some more Lori Vallow stuff I don't have, but there's a considerable chunk of what's going on. Again, we're getting into her trial around the start of June. I'm planning to cover it again, so make sure you subscribe if you haven't, just so it pops up. If you haven't watched my previous coverage, I have a playlist. It's like the Doomsday Murders. That playlist has all of my Lori Vallow stuff, including where I go through like a timeline of what took place in what order for a lot of stuff. And then I go and I watch the Arizona trial, and I have my daily updates. If you're just interested in Arizona trial, I compiled that all into a single video. Maybe that's easier for you to digest. It's like 8 hours long. I know it's long, but if you come in, periodically and listen to it while you're, cleaning or doing the dishes, maybe that would help. That will give you a really good idea of the style of arguments and things that Lori gives, and that will probably set you up to understand what she's going to do in this next trial. But I hope you enjoyed. I hope I laid it out pretty well for you. I tried to do devil's advocate a couple times in this. We'll see how this all shakes out. I don't expect she's going to have the charges dropped. I expect we're going to have a trial.